Number 112. Would you like any rebuttal time?
I would like to reserve 2 minutes, Your Honor.
2 minutes. Okay. Go ahead. Proceed, counsel.
Your Honor, first of all, I'll introduce myself, Philip Rothschild from the Hiscock Legal Aid Society in Syracuse, New York. Criminal Procedure Law, Section 60.22, a defendant may not be convicted of an offense based upon the testimony of an accomplice, unsupported by corroborative evidence tending to connect the defendant with the commission of the crime. Such corroborative evidence must consist.
And the victim's evidence did not corroborate the accomplice's evidence?
It did not tend to connect the.
Well, didn't you say at one point that he was in the courtroom, present with the other two people who had been in the car with her?
Glad you brought that up, Your Honor. Judge Smith's concurrence finding some type of quasi-identification, she didn't rule as identification, just identification sufficient for corroboration purposes. That was not found by the trial court, which had the opportunity to both see and hear the witnesses. And it was when the trial order of dismissal motion was made and when the 330 motion was made, it was not a factor cited either time by the trial court.
How close were they, Mr. Rothschild?
She mentioned that. I'm sorry.
I interrupted you, Judge.
She mentioned that at trial, so obviously it wasn't found at the hearing.
No, this was in response to the motion for the trial order of dismissal. And the trial court had the opportunity, when the trial order of dismissal motion was made, could have cited that. And certainly that would have been the end of it right here. But additionally,
It must have meant, I mean, it surely at least meant that the appearance of the man she saw in front of her was not inconsistent with her recollection of the.
Well, the problem is we don't know what her recollection was because it was all over the place.
Well, she did say something about dirty blonde hair.
Well, she said, actually, the person she mentioned as having dirty blonde hair was the third rapist, who, according to the accomplice, was not Mr. Reome. Mr. Reome was supposedly the second rapist. And she later changed that description of the man with long, dirty blonde hair. She later said he had shorter brown hair and a mustache. She said that 8 months after the fact. Her descriptions were all over the place.
Where would you, I hate to put you on the spot like this, but what is enough? I mean, this seems to be a very ephemeral determination as to what tends to, to prove.
Well, Your Honor, I would submit that 130 years of case law have set down a very simple rule. It has to be evidence tending to connect. The amount is irrelevant.
Well, you don't have to independently establish guilt, and you don't have to prove every element of the crime, correct?
Absolutely true, Your Honor.
But the phone calls seem to be pretty interesting.
Well, those phone calls, the problem with the phone calls, and if I may, those phone calls were in no way independent because they relied for their probative force and value upon the testimony of the accomplice.
Even if you'd suppose the accomplice had never testified, you still have the proven fact by DNA that she's raped by the other three men.
Absolutely, Your Honor.
You can prove that this guy is a close friend of those three.
Guilt by association. That's all it was.
Yes, guilt by association. And then and you can prove that he's calling one of them before the event and after the event, adds up to a couple of dozen times, but that during the event they don't call each other.
Actually, Your Honor, if I may, I believe the earliest phone call beforehand was 6 hours prior, and the one afterwards were 12 hours after the fact. Additionally, I think it was a total.
She also indicated that the second rapist didn't use a condom, correct?
Well, she said that initially.
So that would explain why there wasn't DNA of a fourth individual?
Your Honor, she said that initially. Then she said she didn't remember or didn't see him put on a condom. She later said that upon cross-examination. The problem is, whether he wore a condom or not, again, that depends upon the testimony of Mr. Hilborn, who claimed that he gave Mr. Reome a condom when he, in fact, could not remember whether he himself wore a condom. Remember, when the DNA test came back, he had said he had worn a condom and he did not ejaculate. When the DNA test came back showing the opposite, he then changed his testimony to say.
Well, but you can see how, even if you don't believe what he said about himself, people do tend to minimize their own guilt. But why, what reason is there to doubt the part about his giving your client a condom?
As far as doubt, it's his. The
fact that he is inconsistent about his own behavior doesn't really undermine his testimony that he gave the other guy a condom, which he had no reason to lie about.
Well, that is still bootstrapping, Your Honor, because the fact that there is no DNA evidence from Mr. Reome in and of itself proves nothing.
Well, how did we prove cases before DNA evidence?
Well, that's.
I mean, there was circumstantial evidence that.
Fingerprints, forensics, hair, confessions, identification, and the fact is there was none of that in the case at bar. There's really no identification.
What about that the two stories do kind of match up? While there are some differences, aren't they close enough that the jury could find Hilborn credible based on the, again, relatively lined up stories of the victim and the...
Well, the problem is there still has to be evidence tending to connect, and bolstering, when there's just merely bolstering the credibility of an accomplice is insufficient. I could give
Yeah, but you do have the phone calls too, right?
Well, the problem is that also is dependent upon the testimony of Mr. Hilborn saying, there was a rape that occurred. The phone calls or absence of phone calls is proof of nothing, and it is burden shifting.
Well, no, we know a rape occurred. You don't need Hilborn.
No, the question is whether or not he was present at the time. That is the issue. The issue isn't whether a rape occurred. The issue isn't whether the car was black or green. The question is whether Mr. Reome was identified. Let's be honest, that's what it is, whether he was identified, whether there's evidence tending to connect him, to identify him in connection with his crime.
In playing that out, I mean, if the three defendants that they've got dead to rights, who are now convicted, et cetera, said we've got to protect our good buddy Smith, I'll pick a different name, Green. So why don't we tell them it was Reome? And so the three of them, or particularly the one that testified, says it was Reome that did it.
And
I'm wondering what tends to, almost Judge Hurlbut's question of dissent. I mean, what ties Reome to it so that you could be confident that they're not doing something like that?
exactly, there has to be some. It's not the quantum of evidence, but it is the type of evidence that is important. That which tends to connect, tends to identify. You can have. I'll give the analogy. You have the question: who was the interior decorator of a room? You have two people go in the room, and both of them say they agree on the color of the carpets, the color of the drapes, the color of the paint, and 1,000 other details. Yet, in and of itself, they have harmonized their testimony.
Suppose that Hilborn is, although he's telling the truth and everything else, he's making it up about Reome. He put Reome there falsely. Isn't it a little surprising that during, as you said, there's quite a long gap between in the cell phone calls, but the cell phone calls between Reome and Buchanan. Isn't it sort of a coincidence that gap spans the time when Hilborn puts Reome and Buchanan together? I mean, in other words, didn't Hilborn get very, very lucky if he's making up Reome's presence and the cell phones just happened to match?
Well, the fact is there was just 3 days of phone calls taken. This was raised by trial counsel. It's like we don't know what the pattern is, and they're claiming some pattern, and the lack of phone calls during this period of time is somehow indicative that he must. Well, these other things.
Well, I mean, isn't it an odd coincidence that if you have the whole risk we're worrying about here is an accomplice who fabricates a story for his own reason. If he fabricated it, he hit the jackpot because he happened to hit a time when there was no phone calls, even though there were phone calls the same day and the following day all the time.
Well, recall also that the incident takes place over 2 or 3 hours. There's an 18-hour gap.
Well, the incident takes place over 2 or 3 hours. Hilborn's account goes on longer than that. He has the 4 guys together for several hours. For several hours, but I mean, there's time during the day there. Additionally, who expects people during the middle of some type of gang rape to go ahead and say, "Hey, guess what I'm doing"? Oh, but his phone has a million calls on it.
There are, and I think there's approximately 8 or 9 phone calls involving Mr. Reome and Mr. Buccino. No, but it's not that Buccino's cell phone goes quiet during the period of the incident. There are a lot of phone calls. It's just none of them to Reome or from Reome. Yeah, that's just. I believe there was actually a blackout period, essentially a blackout period for at least 7 or 8 hours regarding Mr. Buccino. I don't believe there was any phone calls.
My impression was the blackout didn't start till 6 a.m. the next morning.
But whether there was,
when you could infer that he went to sleep.
Whether there was or wasn't, the point is there's a million different details which either they're not independent or they don't tend to connect. And I would cite Nitzberg, this court in Nitzberg, said. Talking about material evidence, it has to be material evidence. If an accomplice could be supported by independent evidence that he told the truth in matters of that sort, meaning non-material evidence, then every accomplice could always rake into his story materials for such confirmation of it. And, Your Honor, I would submit in this case, basically, the materials were not just raked and they were shoveled in by the police. We have the accomplice who was, both during the incident and during the time he was being questioned by police, he was drunk, He was high. He was schizophrenic, bipolar. He was hearing voices. He was eminently suggestible. He was also illiterate.
But we also know that he told a lot of things that were true.
And he told a lot of things that were not. But he also said, point blank on cross-examination, the police told him to say that Nathan Reome was there. That's right there in his testimony. And the police controlled what went into the statement.
What about his emotional reaction when the police tried to talk to him about the rape? Is that corroborative?
I believe it's not. I feel that such evidence has been held. I mean, there's been stronger evidence. False alibis given, running away when being questioned. That evidence has in and of itself been found inherently insufficient as a matter of law.
Well, but those are cases when it goes to the issue of guilt or innocence. Isn't corroboration a much lower threshold?
The corroboration still has to tend to connect. And such evidence in no way tends to connect because, may I remind Your Honors, that innocent people can be nervous when questioned and accused by the police as well.
Is there any way to define tend to connect in a way that going forward would be of assistance to both plaintiff or the people and future defendants?
I'm not going to say you know when you see it, but I believe that it basically has to do more than just bolster the credibility of the accomplice. And in this case, it has to be something independent of what the accomplice is saying, meaning not relying for his testimony upon probative force and saying, okay, well, I'll give you an example.
What case says it has to be completely independent?
Well, there's cases that say that it do have to be independent, Your Honor. I believe that it's Moses, and I believe that it's Kress. There's cases that say it has to be independent.
What about Hudson?
Hudson, I believe, follows Moses as well.
It doesn't Berland kind of undermine? Berland, we seem to say you don't have to disregard the accomplice's testimony completely. You can look at the accomplice and the corroboration and see if they match.
But I believe Breland also really deals with the quantum of evidence and not the quality of evidence, because Breland reiterated what Moses said and says when the evidence, is merely bolstering the credibility, that is insufficient as a matter of law. I believe that, I think my time is just about up.
Okay, counsel. Thanks.
Good afternoon.
Counsel, what does tend to connect defendant to the crime under the legal requirement?
You want to talk about legal standards or you want to talk about facts?
I want to talk what specific things tend to connect.
Okay.
The standard is, let's for the sake of argument, tend to connect.
All right. I would delineate 7 things.
Yeah.
2 of them that are pretty directly implicate the identity of the defendant. That is Hilborn and the victim both talking about the dirty blonde hair. I think his hair does him in.
What about the dye?
That is a curious comment. I'm not sure, Judge. He says, I don't know if he meant that he routinely, I've known him for years, he routinely dyes his hair. It was dyed then, it's dyed now. Nobody explored that. So
As I remember, he said the question was that he has dirty blonde hair. Yeah, but then it was dyed. You could draw an inference from that maybe it wasn't dirty blonde at the time of the event.
Maybe. And I think you could criticize all the things I'm about to say. You could individually criticize each of them. But I'm going to suggest to you that you have to view them together.
Okay, give us the other 6.
Number 2 is the testimony that Judge Separak mentioned at the beginning, where the victim says, I'm in the room with these three people. And, of course, Hilborn, the fourth, hadn't testified yet. He was not in the room. And a clear reference to the 3 defendants, perhaps, short of a positive, that's the man type of ID, but very strong evidence. I'm sitting in the...
Is it consistent with the idea that the prosecutor said, we've got the guys, and she believed them?
Well, let me read it. Let's put it out there. She's talking about having had some therapy, having remembered more things, some things that she was sure about now, and she says that I didn't remember things before, but I'm sitting in a room with 3 people that I can tell you they sat in the car. Now, I think that strongly ties in these 3 defendants who are on trial to this case.
Does it matter that this wasn't one of the findings of fact that the judge made?
I'd suggest no, Your Honor. I don't think you should require the trial judge to delineate every bit of evidence that the judge may view. And even judge might even have a different view than you have today, having looked at the whole record. The judge was present for it. He may have been convinced just at the hair and not really gone beyond that. And but I think the judge has to make a ruling. He did make a ruling. I don't think you should dissect that ruling. He was kind of terse. That's denied. And I think at the close of all the proof, he was even more terse because the defense attorney said, well, maybe my client was home sleeping. And the judge said, well, I'll let the jury decide whether he was home sleeping.
Okay, what's your third piece?
Okay. In no particular order, the other ones are the testimony of McDonald's father-in-law, Mr. Bowe, about them riding around together in the car, and Buccina's, co-defendant Buccina's boss, about the defendant showing up when Buccina would show up for work, linking them together, other than at the time of the crime. Next one, the DNA evidence we already talked about, that you have Hilborn giving his statement to the police before the DNA results are known. How likely would it be that he would correctly name himself, Buccina, and McDonald as rapists who were tied in by the DNA, and then before any DNA results are known, draft in Reome falsely? I think that's corroborative. The telephone records, which we've already talked about, I think there are 14 calls between defendant Buccina on the day of the rape, later in the day, 11 more the next day. Again, this is the same phone that Buccina loaned to the victim to try and call her mother, getting her sister, and then not getting the phone number for her friend before the rape happened. Sixth, the reaction.
Do you rely on just the calls or also on the absence of calls during the incident?
Both, Your Honor. Yes, I think that's significant. And I'd also add that I don't think it's significant whether they picked up, whether they left a message, or whether there was conversation, because a lot of these calls are short. But I think with the younger people today, that's not unusual that they leave short messages.
They'll text.
They text. Anyway, I'm sorry, getting off point. I was getting to my sixth, which is the reaction, both when Sergeant Flanagan approaches him to talk to him the first time in March, and then again when he arrests him and they do the buccal swab in July. Both times, his extreme physical reaction. Yes, it could be that you get nervous if you're approached by a police officer, but in the context of this case, corroborative. It shows he's very afraid that the jig is up. And seventh, I would mention that the unity of details between the victim and Hilborn in a way to describe it. Now,
Is that enough in and of itself?
That alone?
Yeah.
Could be. The way I read Besser, your case law.
I'm saying under Besser.
Yes.
You think it is enough?
I think it is enough. Although I think, as I said before, I think his hair does him in. I think that really from the get-go it ties him in very, very clearly. I just want to mention one other thing about their descriptions and the way they tie in. I think you could read this record to show that when the victim first spoke to Sergeant Flanagan, that she reversed the batting order, the rapist order, that she had Buccina second and Reome third, and that when she thought about it more and talked to him more, she had Reome second and Buccina third, which is what Hilborn said. And I think that explains some of the cross-examination about, well, what about the guy number one, guy number two? And I don't think that you should find a lack of corroboration based on that for at least this, I think, initial period, she may have gotten the order wrong. Unless there's any other questions.
Well, just do you have a thought as to, this tending to connect it seems very ephemeral, certainly in the abstract. I guess it gets a little clearer case by case. But do you have any thoughts on how a court defines tending to connect to a jury?
Well, in looking at this case and looking at your case law, it seemed, in my mind, to break down two ways. One is that tending to connect, in a sense, in a more kind of a general sense, that it tends to connect because look at all these things that really would cause you to think that this accomplice is telling the truth. Even if none of them, even if we didn't have the first two things I mentioned, none of them actually bring in an identity. But I believe, reading your case law, Besser and the other cases, I think that is a legitimate approach. That even if none of the corroborative details actually go to identity, but they just make it much more a much more comfortable conclusion, a good conclusion, that this accomplice is telling the truth, I think that's viable. Another way to look at it, and this case would support either way, an affirmance either way, would say that something's got to actually go to identity. But I'd say that the contrast in the case law, the contrast between this case and, say, People versus Moses, where there was a reversal, and even the trial judge, after the verdict, set it aside, saying you had an accomplice who was just the former girlfriend of the defendant, was obviously out to get him, and the trial judge said, after he set aside the verdict, said, gee, this I think maybe an innocent man was found guilty, and set it aside, and that went up to this court, and you agreed that the conviction cannot stand.
What, if anything, is the relevance of the fact that there seems to be a fifth person's DNA, or I guess a sixth person, there's DNA, maybe a fifth in the car?
That is, in my opponent's brief, tried to characterize as a fourth attacker's DNA. I wrote this down so I didn't get it wrong, from page 1150. Non-sperm fraction stain, which I would take to mean some sort of DNA, not semen, not sperm. Could have been from the clerk at JCPenney who sold the victim the clothing. Could have been from somebody who tried on that clothing in the store. She stated.
Where was it found? On her clothing?
On one of her two socks and her pants. And of course, she wasn't wearing the pants. The pants were outside the car during the rape. But she put the pants back on and put the socks back on. I think the fact that it's non-sperm would show that it doesn't really, especially taken with all the other things we have here, amount to something so significant that you should find that the corroboration was insufficient. And I just wanted to get back to Moses for a second. That case was where there was the very suspect accomplice testimony and very little corroborative evidence. I think we have the opposite here. Yes, there's a general suspicion of an accomplice testimony, but with all the factors we've shown, there's not a whole lot of reason to suspect that Hilborn named Reome falsely, and we have at least 7 areas of corroborative evidence.
What about the DNA evidence?
Again, I see the DNA evidence, even though DNA was not found from Reome, from our defendant here, that it corroborates his use of a condom, which both Hilborn and the victim talked about, that it shows that when Hilborn gave his statement to the police and named these people, and by the way, he doesn't say that they fed him the names. He says that they asked him if he knew these people, and he admitted he did. So I would quarrel with the characterization that it was the police feeding it to him.
Even if he used a condom, wouldn't there have been DNA from his sweat, and if the event occurred and he was the man?
Well, if you read the victim's testimony about when he was in the car, he not only a condom, but he didn't ejaculate. And so, whether he was sweating, it was in October at night, I'm not sure if he'd have sweat or not, and whatever DNA he did have ended up a very small part of a mixture that couldn't be detected, that's possible as well. But I think the DNA evidence, though, doesn't include him. It doesn't give cause to say that this is not enough proof, that it's not corroborative.
Okay,
Thank
thanks,
you.
counsel.
I'd ask you to affirm.
Thank you. Counsel, rebuttal?
Yeah, Your Honor, first of all, page 938, and when they questioned you, this is the cross-examination of Mr. Hilborn, when they questioned you, they were telling you which names, people that you were with. Is that correct? Yes. Secondly, unity of details sounds a lot like harmonization, and the fact is those details, that harmonization was provided by the police. That is the danger. That is the danger that was warned of in Nitzburg. The corroboration details, the 6 details that Mr. Maxwell went over, I would submit, none of those were found by the trial court that they had the opportunity to see and hear the testimony. None of it was found by the 4th Department, which had the opportunity to make findings of fact and reviewed the whole record at length. It was implicitly rejected by the plurality. Regarding the DNA, the fourth person's DNA, they said, well, it's non-sperm fraction. The fact is, other defendants also deposited non-sperm fractions as well. And these stains were found right next to other stains found on her pants. They were stains from other contributors. Basically, what Mr. Maxwell is saying is because there was a claim that there was blonde hair, that it is in of itself. I would submit that the idea that because she at one time mentions blonde hair and then she later changes it to say that it's brown hair and a mustache, you have a wealth of details, none of which tend to connect the defendant. That is the rule. It has to tend to connect. It has to tend to identify. It's going back to the analogy of the interior decorator. You can have a million people talking about the different details in the room. None of that identifies the interior decorator. And that's what we have here, Your Honor. We have, and I would ask that there be reversal because just as a matter of law, they have not met their burden. Thank you.
Okay, Captain. Thank you.